I'd like to talk for a second about the patent and trademark application processes and what the inventor or the small business person should expect in terms of costs along the way. When you first decide to apply for a patent or trademark, there's an initial application fee. Once that has been paid, along with submitting the application, there's something called the official filing receipt that's sent back. Now, somebody has to, or I should say somebody should review that, because quite frequently the U.S. Patent and Trademark Office will make a minor mistake, or they'll point out something that was missing in the application. And it's important to catch that, because unless you catch that and rectify the error or point out to U.S. Patent and Trademark Office their error, you can end up having your application abandoned. Then probably once you get your official filing receipt, there's nothing that's going to happen until the application is actually examined. However, in the case of patents, both utility patents and design patents, sometimes the drawings are rejected. Now again, if you had a professional patent illustrator, as opposed to somebody you know who owns Photoshop, prepare the drawings. The chances are, if there was a rejection, it'll be a minor one. If, on the other hand, you tried to do your own drawings or use somebody who wasn't experienced with patent illustration, there's a good chance that the drawing revisions may be fairly major, so expect to pay some more money for that. Then once the application is examined, in trademark cases, probably over 50% of them are allowed right off the bat if you've had a decent trademark search done ahead of time. And so at that point, we basically have to review what's called the notice of allowance, or the publication period notice. And at that point, after, you can probably get your trademark fairly quickly thereafter. In the case of patents, when the office action comes back, it's usually a fairly lengthy discussion of what is and what is not patentable in your invention. Now, again, when an office action comes back, this is a preliminary view of the examiner. And the first time around, especially under the, well, not so recent, but fairly important case of KSR versus Teleflex and its progeny, the first office action is often a rejection of all claims. And then you have to come back with arguments on why you think the device should be patentable over the prior art. If you've had a professional prior art search done, hopefully they found most of the prior art, so the examiner's objections or rejections will hopefully be minor. If, on the other hand, you didn't have a prior art search done, or you had an amateur one done, then odds are the examiner's going to find some prior art that may be very, very damaging to your application. So somebody has to review that and decide whether to move forward. You can have your patent attorney do it, or you can do it on your own and then run it by your patent attorney for a second opinion. In either case, though, once you start using up people's time in reviewing these things, expect to pay more money for it.